Members, good afternoon. Contracts, rights of third parties bill. This is the third meeting of the Bills Committee. We've got a quorum already. Ms. Sit Ho has written to me indicating that she would like to withdraw from this Bills Committee. Right, so we have a total of 10 members in the Bills Committee now. Mr. Lee Mason, yes, please invite the administration in first.
Tony.唔識佢哋啊！哇，咁我要查證，唔識佢哋，好驚。Outsider。好，各位政府。
Right. There are some outstanding issues from the last meeting. First of all, we've got a paper from the DOJ responding to the submission from Mr. Lee Mason of the Faculty of Law, Hong Kong U, and also the submission from the Hong Kong Association of Banks. In fact, we did have some discussion at the last meeting, but members said they preferred a written reply. So this is CB4 815-1314 bracket 01. And now can I invite Mr. Wong, Deputy Solicitor General, to take us through the paper. I think I'll invite Ms. Zhang, my colleague, to go through the paper with members. Yes, thank you. Yes, Chairman. I will merely highlight the salient points because, as the chairman has pointed out, there in fact was a discussion at the last meeting with members. First of all, some views expressed by Mr. Lee Mason, Assistant Professor of Faculty of Law, Hong Kong U. Mr. Mason noted that in the UK Act, the Unfair Contact Terms Act 1977, and he queried why the bill contained no equivalent provision to disapply Section 7 bracket 2 of the Control of Exemption Clauses Ordinance. No, in fact, when we look at exemption clauses, we have to look at whether they are reasonable or not. The LLC has considered the issue. And The LLC is of the view that there exists no compelling reason for distinguishing promisees from third parties where the protection of Section 7.2 of Cap 71 is concerned. And so Section 7.2 of Cap 71 should apply where a third party sues the promisor under the bill for negligence, which consists of a breach of a contractual obligation. And then concerning the promisee, whether he has to qualify the sum to the third party. We've taken into account the LLC's view. So in general, we follow the common law. And we haven't expressly provide for the promisee's duty to account to the third party for the sum the promisee recovered from the promisor. And then let me now go to E. In a mediation agreement, whether a third party will be bound. So I refer to clause 4 bracket 4 of the bill. A third party's right of enforcement of a term of the contract is subject to any other term of the contract relevant to the term. We've made reference to some advice and overseas examples. And we are of the view that clause 4.4 also includes arbitration or other means of alternative dispute resolution, including mediation. And so we think that a specific provision on mediation is not necessary. Then finally, G. According to Mr. Mason, the LLC report was completed a decade ago. And so the administration should have taken into account the recommendations of the report as well as other recommendations. So we wish to make it clear that we've made reference to the recommendations of the LLC report, and we've also studied jurisprudence developed in other common law jurisdictions. And we also took into account views received during the consultation exercise. And next, we'd like to respond to views expressed by the Law Society. A. Whether the new legislative scheme should not be applicable to variation or rescission to an agreement entered before the commencement of the bill. Now, Clause 3.1 provides that the bill will not affect contracts entered into prior to the commencement of the bill. Now, the bill will apply to a contract, including a supplemental contract, entered into on or after the date on which the bill comes into operation. However, it will be open to the parties concerned to make clear their contractual intention in accordance with Clause 4.1 and Clause 4.3 of the bill. And then E. The Law Society, and this is in fact F. Clauses 11.1 and 2 concerning double liability on the part of the promisor and offering protection for the promisor, it is stated that there will not be double liability. The Law Society thinks that we are stating the obvious. But then we've taken into account the LLC's recommendations. The LLC is of the view that this should be spelled out, and that's why we've spelled it out explicitly. And then HKAB. Many of the comments relate to the drafting of the bill. 3A. They hope that there will be sufficient time for them to prepare the legal documents. They hope that the law will come into effect 6 months after the passage or enactment of the bill. We welcome this suggestion, and the bill will, or the new law will apply to new contracts 6 months, or at least 6 months after the passage of the bill. And of course, there are other drafting points concerning G. It's about the court being able to dispense with the third party's consent to a rescission or variation. And the HKAB has laid down a number of scenarios. Now we are now proposing a general power. In other words, if the court considers it just and practicable to do so, then it can exercise the discretion to authorize variation or rescission of contract without a third party's consent.
The last comment is in K. The HKAB suggested that consideration should be given to non-exclusive jurisdiction clauses. They are saying that apart from such jurisdiction clauses, there should be an inclusion apart from jurisdiction clauses and non-exclusive jurisdiction clauses, as these would be far more common than exclusive jurisdiction clauses. We consider that Clause 4.4, under which third parties' right of enforcement of the relevant term of the contract is subject to the contract's other terms, including procedural conditions, we have considered both exclusive and non-exclusive jurisdiction clauses. And also the parties to the contract can refer to Clause 4(4) for the inclusion of both exclusive and non-exclusive jurisdiction clauses. Thank you very much, Ms. Zhang. So these three written responses, that is from the HKAB, Mr. Lee Mason, and also from the Law Society, have been dealt with by way of a written response from the administration. Members, your views, please. There being none, we go on to the next paper, that being CB(4) 815-13-1402. And that is some of the questions that members have raised at the previous meeting, and the administration is coming up with the responses here to the questions raised. Yes, there were 4 areas where clarification was required. In the definition of third party, it was raised whether we should make an amendment there. We have carefully considered the suggestion. There are 2 reasons why we should retain the present practice. Now, the suggestion is under third party, there should be a more lengthy description, and to peg that to 2 and 4, clauses 2 and 4. And that is, it is suggested that the definition of third party in the bill should be defined with reference to clause 4, bracket 2, so that the reader can easily realize that the term refers to a third party who is expressly identified in a contract to have a right to enforce a term of a contract. And this is to for clarification purpose, it says. But we do not consider that this is an appropriate approach because the bill deals with third parties' rights under a contract. It does not confer those rights on all third parties to a contract automatically or unconditionally. A second reason for not adopting the suggested approach relates to a general rule for drafting definitions in any piece of legislation. The reader expects a definition to stipulate a meaning and is entitled to assume it does no more. Therefore, it is a practical rule for drafting definitions that a definition should not include substantive matters. Now, in the bill, we have also included or rather excluded a deed of mutual covenant from the application of the bill, clause 3(2)b. Our core consideration is with regard to ownership of buildings, and in fact, DMCs, a deed of mutual covenant, we seek to exclude from the application of the bill because we consider that to allow third party to a DMC a right to enforceability under the bill would contradict the underlying policies of existing legal mechanism for enforcing a DMC by a third party. And in the submission given to the LegCo on the 22nd of May, we have already explained that the reasoning therein. And the reason why, if I may supplement, the deed of mutual covenant would actually include a number of parties, including the management company, the owners, etc. And there is a clear set of delineation as to the rights and responsibilities of each of the parties. And also there is the building management ordinance as well, and the conveyancing and property ordinance, which govern this law relevant to building management and enforcement of rights under DMC. And we are now considering third parties' rights in enforcement of contract terms. And in so doing, we do not want to provide additional responsibilities to the third party. And looking at the DMC, the main thrust is concerning the relevant land and the relevant legal responsibility, especially for the landowner and the successor of the ownership will all have legal responsibilities arising for them. And in paragraph 7, we have mentioned that in response to the view expressed by the Bar Association that given that there is already a legal regime of the DMC which has been fully consulted upon, and there is this clear DMC stipulations, we think that this should be taken out of, that is, the needs of regulating the occupation and management of multi-story buildings or estate developments in Hong Kong be taken away from the applicability. And also for paragraph 9, regarding the question raised at the last meeting, whether the proposed exclusion of DMC from the bill would render tenants of private buildings and users of common parts of private buildings who are not owners of private building not able to rely on the bill to enforce a term of the DMC. Actually, there are already exclusions to the DMC, whether it's third party unrelated to the building or tenants. It will be difficult for them to use or based on the DMC to make certain claims. But on the other hand, for visitors, etc., there may be negligence cases, but that will not come under the DMC. So in that sense, we have not detracted from the existing legal rights, and also we have considered the Bar Association's view. We do not want to complicate the legal issue here, and therefore this is our response. Thank you, Mr. Wong. Members, concerning this point, do you have any questions? No. As for C and D, if I may, Mr. Chairman, very quickly bring us through. C, concerning issues relating to a chain of contracts. In the last meeting, we have already said that if the parties to the contract very much want to confer a benefit greater than that in the contract between D and C, we are asked if D would be allowed under the bill to enforce its right under the head contract, which would result in a larger remedy, and the justifications. We consider that under the bill, as long as the relevant conditions, including test of enforceability under Clause 4, are satisfied, D would be able to enforce the rights conferred on him under the head contract. And the object of the bill is to enable a third party to enforce a term of the contract, if this is the intention of the contracting parties. As for D, the Chinese text of Clause 4.3, we have carefully reviewed the wording of the clause. We maintain the view that the existing version, which consists of 2 lines and 4 short syntactic units, reflects the policy intent appropriately. And after careful consideration, we do not see a genuine need to change the version in Chinese. Thank you very much. Yes, on C and D of the response, do you have any questions? No? Colleagues? No. We now go on to the next paper. Mr. Wong will bring us through the next paper. In fact, Mr. Wong had already brought this to our attention, but in the third meeting we didn't have the time, and that is on the 24th of April 2014, the administration had responded to the request of members for their supplying case laws on UK Contracts Rights of Third Parties Act 1999 and case laws in other common law jurisdictions on the application of similar legislation. The paper I'm referring to is CB bracket 4 623/13-14 bracket 01. Yes, indeed, Mr. Chair. Perhaps Ms. Aoyang, my colleague, can go through some of these case law and why we have chosen these particular case laws. Yes, if I may bring us through the 4 case law, 2 UK case law, 1 New Zealand, and 1 Singapore. First of all, the 2 UK case law. Firstly, Nissan Shipping Company Limited versus Cleves. There are 2 main issues which have been given guidance by the court. The first being the applicability of evidence, and the second one being the arbitration. Now, first, on evidence. Before we go into the facts of the case law, if we can just revisit the subject, that is where the parties to the contract had provided a certain right to a third party, then the third party can exercise or enforce the contract unless it is expressly expressed by the two parties to the contract that the third party cannot enforce the contract. And we have the concept of rebuttable resumption. And this is a case of Nissan Shipping Company where there are two parties, and that is the commissioner and the commission for a charter for shipping, and also a broker, and a commission is payable to the broker, and we all understand that the broker is to be paid a commission for his work. So this is a case pertaining to that kind of a relationship. And the question is whether the third party can enforce the contract, and that is claim the commissions outstanding to the ship owner. The most important point is whether within the contract there are clear expressions or terms to say that the third party can enforce his right, or whether it is neutral. And after looking at the contract, the court decided that the third party will be able to enforce the contract terms, and therefore be the parties are obliged to pay the commission.
And then the arbitration provisions. The third party is not specified as one of the parties to the arbitration, but then the court is of the view that should be entitled to claim against the owners as if they were parties to the contract. And so there must be this arbitration. And so when a third party seeks a claim from the ship owner, it has to be bound by the arbitration provisions. And in this case, the court is of the view that the arbitration agreement can cover the controversy on commission. And so arbitration can be carried out. Now, we are of the view that this case is important because of two reasons. First, this is the first case in the UK on the relevant act. And then it provides a clear definition for mandatory enforcement. And it also states clearly when arbitration can apply to a third party. And the principles are clear. And then there is a second case. Sorry, Ms. Ouyang. Concerning the case Nissan Shipping. In fact, some members have asked questions about arbitration agreements. And what if there is a mediation clause in the agreement? Now, because the bill doesn't cover mediation arrangements, what if there is a mediation clause in the contract? So, is it that the mediation clause comes before the right to seek claims by third parties? Who can give a reply? Chairman. We do not have provisions on mediation, and so under clause 4.4, we have to comply with clause 4. But then we have clause 12 on the arbitration agreement. But then we have to look at clause 12 together with clause 4. Mediation first and then arbitration. If that's in the contract, then we'll have to follow this procedure. But of course, it ultimately depends on the intention in the contract. Ms. Ouyang, I want to now take members through the second case, and that's the Crowson case. So it's a contract between a company and a broker. The broker has agreed to put into effect insurance policies, including a directors and officers liability insurance policy. But then the broker has failed to make the arrangements. So one of the directors is Crowson, and he seeks claims from the broker. He is of the view that the broker is negligent and there is breach of contract resulting in loss on his part. And the broker is of the view that the claim should be struck out on the grounds that it doesn't owe Crowson a duty of care at common law and that it is not in a contractual relationship with Crowson. But then the courts do not rule in favor of the broker. The court rules that the contract confers a benefit on Crowson, namely insurance as a director. And then second, Crowson as a director fulfills the description in the bill concerning third party. We have chosen this case because you can see how the bill can help the third party. Concerning the Crowson case, concerning insurance taken out for a third party, for example, directors' liability insurance policy, or accident or medical insurance taken out for the staff and their family members, then there can be claims made against the insurance company or the broker. So this is the Crowson case. So you are saying that in this case, it is made clear as to what the benefit of the third party, but it depends on whether there is an effective exclusion clause. If both sides have included an exclusion clause, then this scenario doesn't apply, correct? And then we have the New Zealand case, Chairman. It involves an agreement on the purchase and sale of property. And then concerning the description of the seller, Mr. Parsonage and his nominees. And it's this description in line with the description in New Zealand law on a third party. In fact, in New Zealand, there were previous court rulings, and concerning the Parsonage case, the ruling was handed down by the Supreme Court of New Zealand. according to the Supreme Court, the reference to nominees was enough to satisfy the definition of the third party. Now, because the definition is certain and clear, and the person once nominated, the nominee becomes identifiable with certainty. And so concerning the description of the third party, our approach is very similar to that in New Zealand and in the UK. For example, mentioning the names or fulfilling a certain description, and that can satisfy the definition of a third party. And so if in an agreement or in a contract there is a nominee that may be regarded by the court as sufficient to satisfy the condition. Yes, thank you. The last case is a Singaporean case, and it's a shareholders contract. A few doctors were or are the shareholders of this company. And this contract contains a restrictive covenant or a non-competition clause. It says that if the doctor leaves the company, or if any doctor leaves the company, he will not commit any act or engage in any behavior which will constitute competition with this company, or else compensation will have to be paid. And the company sues one of the doctors for having breached the restrictive covenant or the non-competition clause. But then the company is the third party. So the crux of the matter is whether the company as a third party can enforce the non-competition clause. And the High Court of Singapore has decided that in the shareholders contract, it is said that the parties concerned have the right to terminate the contract, and there can be free assignment. And the High Court is of the view that with these provisions, then the contracts to the party, in fact, do not want the third party to enforce the benefits. But then the ruling was overruled by a higher level of court. The court rules that the mere existence of a general provision against assignment of a party's rights does not have the effect of rebutting the party's intention to confer enforceable rights on the company. And concerning termination of the contract, in Singapore there are laws clearly stating under what circumstances the parties can end or vary certain rights, though such acts may affect the rights of third parties. And so the fact that parties concerned are allowed to terminate the agreement do have certain implications. Now we've chosen the Singaporean case because it gives us guidelines on the application of rebuttable presumption. And then concerning rescission and variation of contract, the situation is also made clear because The principles adopted in Singapore are very similar to those adopted in the UK. And in fact, our provisions are also broadly comparable to those in the UK. And so the Singaporean case will also help us understand how the clauses in this bill on the principles in this bill should be applied. All right, do members have any questions concerning these cases? Now, Mr. Wong, you've studied these cases and also leading cases in common law jurisdictions. So do you think whether the provisions in this bill will give rise to court cases like these outlined in the paper, Mr. Wong? Now, we, of course, seek to achieve the greatest clarity in our provisions. And it's like 41B and 41B and 43. Whether the interest or rights should go to the third party. It really depends on the content of the contracts. And I think these cases can enable us to understand the application of these provisions. And of course, if there are other cases in the future, we'll take them into account. But I think we are, well, of course, we have already tried our best to achieve the greatest clarity in the bill.
Let us go back to the third meeting. We'll now go clause by clause. As I remember, the Secretariat record show that we were at 6.1 last time. Have we completed 6.1, please? The Secretariat tells me that 6.2 has been completed, at least 6.2A. Well, shall we do this? Shall we start from 6.2 and go clause by clause from 6(2) on? Yes, thank you. Concerning the rescission and variation of contract, we would like to balance the parties to the contract and the ability to vary the contract and under what circumstances there will be certainty for a third party. And that's why in 6(2) we point out the situation where the third party has already given consent to the benefits or had relied on the terms and has assented to the term, and the promissor has received notice of the assent, whether the assent and the notice are in writing or otherwise, or the third party has relied on the term and the promissor is aware of the reliance, or the promissor can reasonably be expected to have foreseen that the third party would rely on the term that would be relevant to this 6.2 on rescission and variation of contract. Yes, give me some time to look through 6.2 again, Mr. Wong. A, B under 2, that is either or, is that right, as a condition? That is correct, sir. Now, it says 6.2A. The promissor has received the notice of the assent, whether the assent and the notice are in writing or otherwise, it says. In writing or otherwise, quote unquote. So this would, a verbal assent would also suffice? Why use the word assent? That is my question. Does it include the third party conduct? By third party's conduct, it may be construed as assent. But if a third party has done certain actions, it may drop or be covered by 2B instead. So what does otherwise include, may I ask? Yes, I agree with the chairman in saying that certain conduct or behavior would also constitute this. But where there is behavior, it is more likely that will fall under 2B, and that is the third party has relied on the term and the promisor is aware of the reliance. And that is sufficient that would be sufficient for the two parties to the contract not being able to carry out rescission and variation of the contract without the third party's consent. Yes, I'm looking at 6.2 Roman numeral 1. The promisor is aware of the reliance, it says. Aware or is aware of this term. Is this an actual awareness, or is it should have been aware of the situation? Is this aware referring to bona fide or awareness in reality, or under reasonable situations for a reasonable man, he should be aware? Well, Mr. Chairman, I agree. Again, that put together with B2, then the understanding of B1 should be actual awareness, because B2 is more objective in nature in the sense that the promisor can reasonably be expected to have foreseen that the third party would rely on the term. So under B2, it is more objective, even though in actual fact the promisor is not aware, but given B2, it would be sufficient. So B1 is actual awareness, B2 is an objective test concerning foreseeability. Very good. Legal advisor. 6.2, just to confirm the legislative intent, 6.2a, it says received notice of the assent. In the Chinese, there is certain wording. And in the Chinese, is it actual receipt of notice? If the notice is sent by mail, then the postal rule should not apply. But this is about actual having received the notice. Is that true? Mr. Chair, I confirm that this is actual reception of the notice. That is, the notice had been received. Thank you. Anything else? Or 6. Let us now go to 6(3). I would like to read that together with 6.4. This is about exclusions through certain arrangements for between the parties to the contract to not follow 6.1. This is also acceptable. That is for 3A. The third party need not give consent. And if there is this clause inside the contract to say that one or more parties to the contract may rescind or vary the contract without the third party's consent, that is admissible and acceptable. And also, if the third party's consent to rescind or vary the contract is required in circumstances specified in the contract instead of those set out in subsection 2A and B, that is fine too. And bracket 4, subsection 3 applies. It says only if before the circumstances set out in subsection 2A or B occur. And that is where the third party is aware of the term referred to in subsection 3. That is the terms that is varied or rescinded by the two parties to the contract, or one or more parties to the contract have taken reasonable steps to make the third party aware of the term. So that is to give third party a certainty on the one hand and at the same time provide certain flexibility. Yes, questions 3 and 4, members? Yes, concerning 6.3, a drafting point, if you will. Yes, we have already written to the administration and they've given us a written response. 6.3. In Chinese it is 在这, in English it is in addition, and we sought clarification from the administration whether they need to put this in as the first term in this clause. In fact, to put in addition, quote unquote, as a beginning of to begin a clause, I cannot say I've seen it before. The administration responded that this is the new style of drafting, and it is the narrative style of drafting, and it is a new style of drafting. That was their response. And basically the purpose is to provide a linkage between 6.12 and 6.3. And in fact, it's been explained to members in the previous meeting that there is a new principle in drafting that unnecessary words be taken off. So we suggest that for 6.3, instead of using 在这 or in addition in English, the import and the effect of the law or the legislation would still be the same. So the question is whether this new style of drafting is necessary here. Mr. Wong, can you respond to that? Why is in addition or 在这 in Chinese is necessary? Mr. Chair, in our response, para 15, that is dated 22nd, we have already responded to exactly that point concerning the drafting of clause 6. For 3 and 4 put together, it is a rather exceptional situation. So we have considered the structure, and we want this to be a read more clearly and more in totality so that the reader will understand the relationship within the clause among the different subsections. Mr. Chan? Yes, just a point of supplement. For our letter to the Secretariat, we have mentioned that we try to take out unnecessary wording, but where for legal, if there is no legal effect for certain wording, but it helps with the understanding and comprehension of the reader, we will be using such words. For example, in clause 6, in addition, quote unquote. First of all, setting out the express terms of the contract, and then in 2, setting out further the situations for rescission and variation, and then in 3 to talk about the exemptions. We believe that to have a linkage in the words in addition does throw light for the reader in their effort to comprehend the legislation, and this is really a much more common new style of drafting. Mr. Chan, are we unique in Hong Kong, or is this a common law or English jurisdiction common way of drafting? Well, Mr. Chair, in recent years, this is a new style of drafting using simple English. There will be more and more of such cases. Less so in the UK, but even more so in Australia. In addition, however, or even but were used. I've seen them. Any other questions, members? If not, we go to the next clause. Yes, Mr. Wang. 7. Power of the court to dispense with third parties' consent to rescind or vary contract. Seven 1. It says that the section applies if a third party's consent is required to rescind or vary a contract under certain sections of Clause 6. I basically want to talk about 7.3b. The court may make the order, and we have taken a more wider approach. The court will have to think that it is just and practical to make the order. And we see that the Law Society is in support of this. And this is to give the court sufficient room to make the decision as to whether it is just and practicable to make the order, and that is to dispense with third parties' consent to rescind or vary the contract. But of course, it goes on to say that there can be other conditions. For example, the third party is given certain compensation. That's in bracket 4, and this is the legislative intent and the content for Clause 7 there. For Clause 7 drafting, have we referred to case laws or certain judgments in certain jurisdictions? And also for 7 bracket 4, a condition requiring that the third party be compensated. Do we have case law? Do we have this judgment being enforced from other jurisdictions? I think this should follow the compensation as enshrined or implied in the contract. Is that not so?
Mr. Wong. Now, to a certain extent, we've made reference to the UK 1999 Act, but then there is a principle which is wider in scope, and that is under 7.3b, the court thinks it just and practicable to make the order. In the UK, the criteria are more specific and restrictive. But then we've adopted the recommendation of the LRC. And then concerning compensation, we are not prescribing the compensation concerning losses according to the contract. So it gives the court the discretion to decide on this. Yes, I understand that there is the separation of powers. But then I just want to know whether you've consulted the judiciary on provisions that affect the judiciary or the judicial sector, Mr. Wong. We have consulted the JA, the Judiciary Administrator. Now, this bill lists the principles, and the LRC has on its list of members the CJ, and so I think this has been fully taken into account. So, Mr. Wong, can we now move on to Clause 8? Yes, Chairman, proceedings brought by third party. So we have subsections 2, 3, and 4 applying if a third party brings proceedings to enforce a term of a contract under Section 4. Subclause 2, the promisor may raise one or more of the following matters by way of defense or set off. So there are 3 different situations, A, B, and C. A, a matter that arises from or in connection with the contract and is relevant to the term and would have been made or would have been available to the promisor by way of defense or set off if the proceedings had been brought by the promisee, in other words, the other party to the contract. Perhaps I can give an example. For example, exemption clauses. The promisor may include in the contract a term excluding or exempting his liability. And so the promisor can use this as a defense against the promisee. Or the contract may become invalid because misrepresentation is involved, and as a result, the promisor may use this as a defense. So that's 2A. And then 2B. A matter in respect of which an express term of the contract provides for the matter to be available to the promisor by way of defense or set off in proceedings brought by the third party. And the matter that would have been available to the promisor by way of defense or set off if the proceedings had been brought by the promisee. And let me give an example. Say in the contract, it is stated very clearly that the promisor can use the debts concerned as a defense or a set-off. And as that's stated in the contract, the promisor can make use of the situation as defense. For example, the debts concerned can be used to offset the compensation. And then 2C, a matter that would have been available to the promisor by way of defense or set off if the third party had been a party to the contract. Now say, if the third party commits misrepresentation and has misled the promisor into making certain promises in the contract, then that would be a scenario under C, where the matter can be used by the promisor as defense or set off. So these are the reasons that the promisor can make use of for defense or set off. Yes, Mr. Wong. I know you are talking about misrepresentation or warranty in the contract. In the contract, misrepresentation is carried out by one party to the contract to another party to the contract, and this may not have anything to do with a third party. Say if there is really misrepresentation. Then under what circumstances can the promisor rely on the misrepresentation as a defense? Yes, Chairman. Now, if one party uses misrepresentation to mislead another party in the contract to make certain promises, I believe we are mainly talking about the situation. But then, under the UK law, for a situation under 2C, now, say, parties to the contract, A and B, signed the contract, but before they signed the contract, a third party might have misled the promisor, and as a result, the promisor made certain promises to the third party. So if the third party has carried out or committed misrepresentation and has misled the promisor, then such misrepresentation can be relied on by the promisor as defense. Thank you. And then 8.3, counterclaims. But the premise is that the matter doesn't arise from the contract. This is because we want to give the third party some rights, but not a burden. For example, the third party may owe the promisor certain amounts of money. So there is a debt, and the promisor may raise a counterclaim against the third party. This is an example that I can think of for this one. And then 8.4, 2A, C, and 3. There can be restrictions, and as a result, the promisor may not be able to make use of certain matters for defense, set off, or counterclaim. And then 9.1, please. A third party or proceedings brought against a third party. And if the third party may not seek to enforce a term of a contract, if the third party could not have enforced a term had a third party been a party to the contract. If the third party, if it is a party to the contract, then it cannot make use of this right or enforce this right. For example, a promisee may have used fraud or improper influence to make the contract null and void. And so if the third party starts a lawsuit, then he would also be subject to these principles. And also if the third party in his counterclaim and I want to say that in the laws, in the contract, the rights may not be enforceable. I want to clarify one point. 9. We're talking about situations not enforceable in the contracts, and you are assuming that in some cases the third party may be a party to the contract, estoppel, misrepresentation. As a result, the third party So you are regarding him as a party to the contract. Yes, correct. So if the third party is a party to the contract, the rights cannot be enforced because of provisions in the contract law. For example, undue influence, misrepresentation, and so on and so forth. Any questions? Then let's move on. Clause 10. Section 4 does not affect the promisee's right to enforce a term of the contract. All right, let's move on. Clause 11. This is to protect the promisor from double liability. We've made reference to Section 5 of the UK Act, but we've also supplemented it. If the promisor has already wholly or partly performed the obligations, then of course it has to be noted that he has already done that. But then concerning so we are staying here under what circumstances the promisor needs not have this liability to the third party. And then there's it is said that subsection 4 applies if a third party may enforce a term of a contract under section 4 and the promisee has recovered from the promisor a sum for the third party's loss in relation to the term or the expense to the promisee of making good to the third party the default of the promisor in relation to the term. So as the promisee has already got either of these, then when the court makes a ruling, it will take into account the award and will also make deductions as it thinks appropriate. And the promisor will not have to face double liability. 11.3, Mr. Wong. It says 3B, all right? The promisee has recovered
a sum for the third party's loss. 但係呢一樣嘢係冇確保到 recover 咗個 sum 係會即係由嗰個
maybe the promisee has not passed on the amount to the third party. Maybe the promisee has just pocketed the amount. Yes, Chairman, we've made reference to the LRC's recommendations. We want to protect the promisor from double jeopardy. So the court will appropriately rule on the promisor's liability. And then the promisee may have obtained some compensation from the promisor. So how can the third party be protected? And we think these matters should be left to the courts and the common law principles. Our understanding is that the compensation that the promisee has got should be passed on to the third party. But then 11.3 seeks to make sure that the promisor will not have to shoulder double liability.
Questions?
你有意見係唔該，法律顧問。
係，多謝主席。其實都係跟進翻主席頭先提嗰啲。
Legal advisor. Just to follow up on the chairman's point, we have written to the administration and we have heard similar questions being raised by deputations. Would the administration please clarify on the basis of the condition mentioned just now, and that is the promisee has recovered from the promisor a sum for the third party's loss in relation to the term, but had not passed on the recovery or the sum recovered to the third party, then would there be another case raised? Will there have to be another case raised by the third party in pursuit of the compensation? Yes, Mr. Chair, I agree with the legal advisor because the purpose is for this clause is to protect the promisor from double liability. Now, if indeed the promisee has recovered from the promisor a certain compensation but is reluctant to pass the compensation on to the third party, then there will have to be certain legal wrangle between the third party and the promisee. Clause 12. Arbitration agreement. Yes, there had been substantial discussion on this. It is made up of two parts, 12 brackets 1 to 3 and 12 brackets 4 to 5. And it says that in 12 bracket 1, subsection bracket 2 applies if a third party's right to enforce a term of a contract under section 4 is subject to an arbitration agreement. And 12.2 is an agreement with CAB 609, and that is the arbitration ordinance concerning a dispute between third party and the promisor. And 12(3) refers to subsection bracket 2, and that it does not apply if on a proper construction of the contract the third party is not intended to be so treated. So for 12.3 actually reflects the relevant understanding of the contract. Mr. Wong, if I can just go through these. One moment. Thank you, Mr. Wong. Please continue. Yes, 12.4, 5. This is procedural, and that is the third party may enforce a term of the contract under Section 4, and 12.4 deals with, and 4 and 5 actually deals with the procedural rights. The specific design is in tandem with the arbitration ordinance CAB 609. The party, that is the third party, is treated as a party to the arbitration agreement for the purpose of the arbitration ordinance. Going to bracket 6 and 7, again 7 in this section, arbitration agreement, has a meaning given by Section 2.1 of the arbitration ordinance. That's CAB 609, because the arbitration ordinance is a fuller treatment of arbitration agreement, mentioning email, mail, etc. Can we talk about the definition of arbitration agreement in the arbitration ordinance? According to CAB 609, basically a written arbitration agreement has to be given. That is, verbal agreement is not acceptable. But what is construed as written? We have to go back to the UN guidance, and that is in 2006. There was a extended definition for what constitutes written. It would include electronic and other alternative means of agreement, written agreement. Yes, we are on 12, clause 12, arbitration agreement. Members, any questions? There being none, let us go on to clause 13, exclusive jurisdiction clause. Mr. Wong, please. Yes. Mr. Chair, exclusive jurisdiction clause is rather particular. As mentioned, this is a suggestion from the LRC. We believe that 4(4) has given the principle in broad strokes, but we have, in any case, honored the LRC's recommendation, and that is for this section, for exclusive jurisdiction clause applies if a contract contains a term enforceable by a third party under Section 4, and B, an exclusive jurisdiction clause. And here we have also given a definition. This exclusive jurisdiction clause regards a dispute between the third party and the promisor relating to the enforcement of the term by the third party. And in this section, exclusive jurisdiction clause means a clause requiring that the dispute be resolved only in a particular jurisdiction. Now, Mr. Wong, the third party and the promisor's negotiation, are there any stipulations or limitations as to how the two parties should negotiate so that they can reach or resolve on a particular jurisdiction, if it is, or is it just a non-exclusive jurisdiction clause? My understanding is that there is a prerequisite, and that is there is a non-exclusive jurisdiction clause in the contract. If the clause is indeed used as a prerequisite for third-party rights enforcement, and where the third party raises a lawsuit, they will have to refer to this particular clause. If it is a non-exclusive jurisdiction of Hong Kong, for instance, then they can, or he can choose Hong Kong because the two parties have both chosen Hong Kong as a jurisdiction. But they can, of course, also look at other jurisdictions, such as a U.S. jurisdiction. In that case, they'll have to follow the U.S. procedures. For non-exclusive jurisdiction clause, at least the two parties have agreed on a particular jurisdiction, but they may seek legal advice if they indeed want to go via other jurisdictions to pursue the dispute. No other questions. We go on to 14, assignment of third-party right. Thank you, Mr. Chairman. A third party may assign to another person a right under a team of a contract enforceable by the third party under Section 4. And that is the right may be assigned to another person. But 14.2 specifies that subsection 1 does not apply if the contract expressly provides otherwise, or on a proper construction of the contract, the right is personal to the third party and is not assignable. But apart from this, same as other rights, they can, according to general legal principles, assign the right, including the third-party right. For right assignment in a contract, there is no specification as to how it is done, at least not statutory limitations. If there is indeed an assignment of right, does the promissor have to be informed of the assignment, the identity of the assignee, for instance, so that the assignee can only then enforce the terms or rights? That's the first question. And secondly, for this assigning of rights, is there a basic stipulation as to what format it should take? Perhaps it is a verbal assignment, or is it a written assignment, or is a deed actually required? Concerning these two questions, can you please explain for my benefit? Thank you. Concerning assignment, we basically rely on personal property principles. According to my understanding, for Hong Kong law, LACO, the Law Reform Amendment Ordinance, there are relevant principles dealing with assignment of rights. I would like to reiterate one point, and that is we have no intention to change or amend the legal principle. That is to say, the general legal principle would be followed. And this stipulation basically just specifies that the right is indeed an assignable right. That is all. So you're saying that all assignment of right will have to follow the Law Reform Amendment Ordinance or other common law principles. Any other questions, members? 14? No? We go on. Clause 15. Yes, again, this is to reiterate the point that since the third party under circumstances will be able to have certain enforced rights, but apart from these, the structure, the third party is not to be treated as party to the contract. And we want to, by so doing, specify that this amendment is basically a very focused one, so that there is no question of making the third party a party to contract. Understand? 16. Yes, this is the last clause concerning the application of limitation ordinance. The courts will have to enforce this, and the limitation ordinance, what is the reference or relationship with the limitation ordinance? And here we say that in section 41A of the limitation ordinance, the reference to actions founded on simple contract includes an action relating to simple contract brought under section 4. And we're talking about 6 years. If it is a special an action upon a specialty, including an action relating to a specialty brought under Section 4, then the 10-year limit would apply. That is, within 10 years, the legal action should have been taken. Yes, thank you, Mr. Wong, for the explanation. Concerning the limitation ordinance, there are two scenarios. One, the so-called simple contract, and the other being the specialty action, including deeds. You mentioned 6 years. When should it start running? The other is 12 years. Did you say 12 and not 10? 12, indeed.
And from when do you count the 12 years or what? When the contract is breached, and when a promise has been made to offer certain benefits to the third party, then the 5 years would count from the breach of contract, and the same applies to the 12-year period. Do members have any questions? No? Then we've finished clause by clause scrutiny. In fact, when we were discussing the Chinese version with Mr. Wong, I was at the same time also studying the English version. So we've dealt with both versions. If you still have some questions, please put them in writing, and I'll forward them to the administration. Can I be given an idea concerning the timetable for the resumption of second reading of this bill? Now, if we want to see resumption of second reading on the 9th of July, then we need to submit a written report to the House Committee this Friday. But I don't think we have sufficient time to complete a written report before Friday. So, Mr. Wong, do you think it's acceptable to have the resumption of second reading debate taking place in October? No problem, Chairman. In fact, the relevant industries also want to have sufficient time to do their preparation work, and so we find it acceptable to have this bill read the second time and the third time in October. Yes, we'll make this recommendation. Let's recommend to House Committee that we'll find a slot in October. In fact, We really hope that this bill can be passed so that a third party can get some protection. In fact, we intended to end at 6:30 p.m., but then there is no need for filibustering in this Bills Committee. So we can end the meeting now. And if you have further questions, you can give them to me in writing and I will forward them to the administration. So I thank the administration, our colleagues, and also the members of the Bills Committee. Thank you.